Okay, it says I'm recording. Okay, and hopefully we got Amber's question. Had to do, was it question 13 or the questions at the end of the discussion questions, and it has to do with what does the shareholders give up in return for receiving the idea of limited liability. And earlier in that lecture, in those discussions, I contrasted the difference between sole proprietorships and partnerships and artificial entities such as corporations, and we made the point, and I hope everybody understands that if you're a sole proprietor or a partnership, you're one and the same with the business, and you are personally liable for the debts and obligations of the business as the owner, since it's one and the same. Um, and so obviously in the example we've been using over and over again, under the doctrine of respondeat superior, if you're an employer, bake delivery goods, right, and your employee, while working within the scope of his employment that is delivering your baked goods, happens to hit the little old lady in the crosswalk because he's texting, right? Everybody with me understand that? If you're the owner, you could find yourself personally liable, what? For the damages caused by the employee's negligence. Everybody agree with that and understand that? Yeah. Now, contrast that, and the same thing is true for partnerships, since partners are one and the same as in the partnerships. But it's different for artificial entities and corporations, isn't it? Yeah. Um, that that shareholders, who are the owners, right? Shareholders are the owners of the corporation, um, and they only have limited liability for the debts and obligations of the corporation, right? They have some liability, but it's limited, and it's limited to what? It's limited to the amount of their investment in the corporation. Okay, everybody understand that? And so if the corporation is organized appropriately, organized properly, run properly, with the board of directors making the decisions, right, having meetings and that being documented. And if that is true, then and so if Billy's Baked Goods Inc. Is if I, as the owner of the sole shareholder, if I'm having my board of directors meetings, they're authorizing the business transactions that are being taken, that I am not operating it like a sole proprietor, that then when the little old lady and her lawyer want to sue Billy's Baked Goods Inc. for the actions. Ryan, you need to mute yourself. Thank you.
Oh, sorry.
That you need to that when the little old lady sues Billy Baked Goods Inc. And gets a judgment because of the employee's negligence, right? Then the lawyer and the little old lady has to look to the assets of the corporations for satisfaction of that judgment. And if the assets of the corporation are insufficient, then they cannot, if the appropriate actions have been taken in organizing and running the corporation, then that the shareholder will lose his investment, right? Yeah, lose his interest in the corporation. But if that does not, if the corporate assets are insufficient to satisfy the judgment, the little old lady and the lawyer can't go after the personal assets of the shareholder. That's the idea of limited liability. Okay, that's a big benefit, right? But what does, and this gets to your question, I think, Amber, what does the shareholder give up for getting that special treatment? What do they give up? We've talked about it before. It's what? Control. Remember, control. A shareholder does not, and shareholders do not have control over the business decisions, direct control over the business decisions of the corporation. Shareholders only get really one thing, and that's the right to vote for certain matters. In particular, the most important one is the right to vote and elect a board of directors. Okay? And you also get to vote on some things like dissolution, combinations, expansion of the equity pool, things like that. But the main thing you get to do is vote to elect the board of directors. And if you don't like, as a shareholder, what the board of directors does, then you only have one. Well, you got two things you can do. You can liquidate your holdings in the corporation, that is, sell your stock, if that's possible, or then you can also at the next shareholders meeting try to elect a board of directors that is more sympathetic to what you want to do. And so what the idea is that you have given up direct control as a shareholder over the day-to-day and the decision-making process by giving it to who? The board of directors, right? The board of directors is the body in the corporation that makes the decisions, okay? And so what have you given up? You've given up that direct control. Contrast that with a sole proprietor, right? He's got all the control. He's got all the, the day-to-day responsibility, but he also has what? He gets all the glory, but he also gets what? All the caca, if things begin to go downhill, okay? So that now the point, so what is the legal doctrine? What do we call that? That's the corporate veil. Okay, that's the corporate veil. Now, make sure you understand the significance of that, and we'll talk about a little bit tonight about Buffalo Creek, is that when you ignore the corporate formalities, and you don't have regular board of directors meetings, when you don't document appropriately those board of directors meetings, when you begin to, instead of having the board of directors vote on resolutions approving dividends or contracts or the use of leasing of corporate assets or buying or selling of corporate assets, that the sole shareholder begins to treat it more like a sole proprietorship and not have board of directors meetings. For instance, just grabbing the corporate checkbook instead of going to the board of directors and getting them to declare a dividend, right? Remember, if you listen to my lecture, if it's possible, which part of the corporation has the sole discretion to be able to declare dividends, right, which is how corporate profits are returned to shareholders. That's the board of directors. And I think I indicated to you that there was a major dispute at Apple between Carl Icahn, a minority shareholder who wanted Steve Jobs to declare dividends, but Jobs controlled the board of directors. Those were his directors. He controlled enough shares of stock to have a majority of the directors on Apple, and they wouldn't do it. They did not declare dividends at Apple for years and years and years. Jobs saying he was going to reinvest all the cash they had into product development and personnel. So Icahn would scream at shareholders meetings and make all sorts of motions and resolutions about declaring dividends, but it doesn't amount to anything because the board of directors would never act on it or take it up. Eventually, after Jobs died, then Icon got the votes and proxies to have the board of directors declare dividends, and Apple has been paying dividends since then. So now what you find is small business people, and we even talk about it in Buffalo Creek, small business people very often, after following the corporate formalities for a few years, then begin to ignore them. And you see, and we talked about that in the hypothetical that I discussed in the lecture. If you look at that about Waters Ranch, Wildhorn Ranch, yeah, and how the fellow ignored the corporate formalities, didn't have meetings, wrote a check out of one corporate checkbook to pay the debt of another corporate checkbook, on and on and on. And he was running it like, not like a corporation, but when you look at how he was running it, he was treating it as a sole proprietorship. And so when some folks got injured on his property and sued him and his corporations for damages, the question became, okay, is Mr. Waters going to be held personally liable? Are we going to pierce the corporate veil? Because what's he's going to do? He's going to waive his corporate charters that have been issued by the state, and he's going to waive those in the air. And he says, well, you can have my assets of my corporation, which are nothing, right? They're shell corporations, paper corporations, but you can't get my personal assets. You can't get my house and things of that nature to satisfy the judgment. And of course, the lawyers for the folks would then begin to ask for corporate records. And when no corporate records appear, and in fact it shows that he was playing fast and loose with corporate assets, treating them like they were actually part of a sole proprietor, then that's then with that sole proprietor, then you don't have your corporate status, right? You lose it. We're going to treat you like a sole proprietorship, and we know sole proprietors have unlimited personal liability for the debts and an obligation of the board. Ryan says, when a company has an IPO, which is an initial public offering, who decides on the board? Generally, simply because the IPO, that does not mean that the company has not been incorporated previously. They would have been incorporated previously. Most likely, there is a small number of shareholders, and this is a little bit beyond the scope of the course, but and I'm trying, let's just take Facebook. Zuckerberg owned almost all of the shares, and some of his partners owned all the shares of Facebook, correct? Everybody understand that? It was still organized as a corporation prior to the Facebook's IPO. And so those shareholders would have elected a board of directors. And that may even been a closely held corporation, that being that there's very few number of shareholders. So I think it was larger than that. And they would have been operating under corporate bylaws and corporate rules before. They would have incorporated in a state. The organizers at the incorporation would have designated who the initial shareholders would be. The initial shareholders would have had a shareholders meeting, would have elected board of directors. The board of directors would have been having meetings authorizing the undertaking of certain actions by Facebook's right running the business and things like that, would have elected CEOs and things like that. The only difference then, what you asked about, Ryan, is initial public offering, is then you're taking a private firm, a closely held corporation that has shares that are not publicly traded, right? They're not publicly traded. They're closely held. And an IPO means that we're going to go public. We're going to become listed on the stock exchange, and we're going to have our shares sold publicly, which entails a whole different level of government regulation with the SEC and things like that. And so that's That's it. All right. So, all right. Phrase from sole proprietorship. Well, you're asking me is that you're operating as a sole proprietorship and then you want to become a corporation. That's very simple. And let's just assume you have one shareholder, and that's fine. All you have to do is go on the Secretary of State's website, fill out the appropriate paperwork, pay the fees. You will be able then to designate who the initial shareholders are. Then once you get your corporate charter, then you simply have a shareholders meeting. If you have one shareholder, that's fine. That shareholder can elect himself or herself as a CEO, and even chairman of the board. But guess what? The Model Business Corporation Act says you have to have at least 3 directors. Hello. And so even though you have one shareholder, right, and you still have to have what? And you can be on the board of directors as that and chairman of the board of directors, but you got to have what? 2 other individuals serve with you as directors. And a lot of times in small family-run businesses, you'll see wives, brothers, different individuals serving as co-directors. And if you think about it, you then as the sole shareholder, even though you're the sole shareholder, the CEO and the chairman of the board, you still be able to take any official corporate action. What you have to get the agreement of who? Your other 2 board members, at least one of them anyway. If a minimum is 3, you got to get 2 of you to agree on any particular proposal that the corporation would like to undertake: payment of dividends, borrowing money, hiring people, on and on and on, right? Yeah, and so, and even in that instance, everybody see and understand, has the sole shareholder, CEO, and chairman of the board given up direct control of the corporation? Yeah, he now shares control of the corporation with 2 other individuals, right? Everybody with me and understand that? Yeah. And so could they block him from undertaking certain actions? Yes. Now, does he have a remedy? Of course he does. He calls a special board shareholders meeting and he elects 2 other people, right? Although sometimes the corporate bylaws may say you can't do that they get to serve for a period of time, but small companies like that. And you can see the temptation too, especially when the wifey poo or the brother or mom, whoever's on the board, starts giving the CEO, sole shareholder, chairman of the board a hard time about he's wanting to do. They oppose him. And you can see how frustrating that will be, could be to someone, and why they would want to begin to take shortcuts. But let me warn you, if you take those shortcuts, right, trying to avoid bringing your fellow board members onto the decision process and documenting those decisions, right? Everybody understand that? That's the crucial thing to understand. If there is no documentation of board meetings and resolutions being passed and adopted by the board of directors, it didn't happen. It didn't occur. You can say it did, and you can have testimony and all that, but the law is not going to take any look at it. We like records. And so, and so, and if you begin to ignore those formalities, the CEO, sole shareholder, chairman of the board has his kids' tuitions due, and he doesn't have time to call the board of directors and doesn't want to mess with it, and simply begins to write checks directly out of the corporate checkbook. We just assume he's authorized to do that, and without having the appropriate documentation that the board of directors have authorized that. And you do that over a period of time. What are you beginning to treat your corporation like? You're beginning to treat it like what? A sole proprietorship. And so if you do that, can you forfeit? Can you lose that limited liability, that status? If you act like a sole proprietorship, then guess what? The law is going to treat you like one. Okay? Important point. And when the law says that you have ignored the corporate formalities, they call that piercing the corporate veil. Okay? Did that answer the question? And I hope so. That's an important part, because we're going to talk about that. If you've read Buffalo Creek, and by now most of you should be working on that diligently if you've not already done it, that was an important issue in Buffalo Creek, for a number of reasons, which I'm going to begin to discuss now, I think. Does anybody else have any other questions about the stuff that that we covered in the first set of discussion questions associated with this, with choice of entities and form of businesses? Okay.
Did you say those were due now? They're not due tonight, right? They're due later in the week?
No. Yeah, I didn't get the thing. I did not get the thing posted until what, yesterday, I think, afternoon sometime. I can't recall. Yeah, yesterday afternoon by the time it got processed. And so I was, and we don't have an exam. You're not tested on it this weekend. And this, since everybody's listening, let me talk about what the kind of the game plan, make sure everybody understands. We're talking about, you have the set of discussion questions that are due Friday on choice of entity and forms of business. You will be tested on that material on the last exam, okay? And so there's no exam this weekend. However, you need to be working on Buffalo Creek, right? There was, I think, one of your assignments was already due on Buffalo Creek, and I think there's another one due at the end of this week, I think, if I'm not mistaken. And so you need to keep up on that. And then the last sections, there'll be a Buffalo Creek part 3 that will be due after the last lecture. Well, Saturday is fine. Yeah, whatever I said in the email, I don't remember. Okay, that's fine. Somebody asked me, is it, you know, whatever I said in the email is what I said is when they're due. I'm sorry, I get and then we will also talk about the material too, more on corporate governance, and in particular, we have to talk about the duties that you as managers and as board of directors and officers and key employees of corporations, what duties you owe them. And that's very important to understand too, and that'll kind of be the last thing I'll lecture on, but that everybody understand that you are a fiduciary as a manager with the ability to hire and fire or otherwise bind your employer to contracts, or as a member of a board of directors, or as an officer or key employee of a corporation. You are a fiduciary of that corporation, which means that you owe them special duties. It's not arm's length transactions. And the real consequences, you need to understand those duties, because if you fail to fulfill those duties, that is that you breached those duties. And as a result of that breach, your employer is damaged, suffers a loss. Guess what? You can find yourself being sued for that loss. And you need to be very aware of that. There are some safe harbors, but those safe harbors generally require that you do exercise due diligence and take certain steps to be able to get those safe harbors. And if you don't do that, you may find yourself looking at a lawsuit from your former employer. And this happens more often than people understand to managers. For instance, not too long ago, I had a manager call me. He said he and his family had left town on vacation for a week or so, that he had thought he had taken steps to ensure the inventory of his store was secured and audited before he left, but apparently he ran out of time and didn't get it accomplished appropriately. And while he was gone, guess what? A bunch of inventory disappeared. Now, of course, he got canned for that right away. and they had fairly good documentation that he was supposed to do XYZ before he left town to ensure that the inventory was appropriately taken care of, and he didn't do it. And what happened was that because the inventory disappeared, the corporation, his employer, made an insurance claim, and the insurance paid. It was essentially a theft. But guess what? The insurance company ended up suing the manager for the value of the claim, for the loss. Everybody understand that? And under subrogation rules, they have a right to do that. And so you need to be very aware of these heightened duties as a fiduciary, because if you breach these duties, you may well find yourself not just without a job, but also facing a lawsuit, and for which you may be responsible for significant damages. And so that's kind of what we're going to finish up with. And the last exam we'll cover the stuff we talked about on forms of business, choice of entity, Buffalo Creek, and then the last stuff I just mentioned to you about fiduciary duties of managers, directors, and officers and key employees. Okay. One of the, Ryan is asking about the Model Business Corporation Act. What is that? Illinois has adopted a form of the Model Business Corporation Act, and if you go to the Secretary of State's office online, you can actually, I believe there's a copy of the Illinois Corporation Act available there. Why I say the Model Business Corporation Act is because each state, there's no federal corporate law, so make sure everybody understand that each state is responsible for adopting legislation that authorizes individuals to do business as a corporation. Okay, it's done on a state-by-state basis, and every state, and in an effort to make state corporate acts uniform, so there's not great big differences, which there was at one time, then some of the legal think tanks got together. I think it's the American Law, ALI, American Law Institute, promulgated a whole series of model acts, and one of them was the Model Business Corporation Act, in an effort to standardize. They're saying, here, we think this is the best set of corporate laws that's around. We've taken a little bit from different ones and said this is the best, this is the model. And then we recommend you state legislatures and governors review this Model Business Corporation Act and then adopt it as your corporate act. And many states have, with very minor changes, adopted the Model Business Corporation Act, including Illinois. And so that's the Illinois has that act, and it's not called the Model Business Corporation Act, but it's called corporations, I guess. But like I said, if you go to the Secretary of State's office, get on his website, you can find a link to the Illinois version of that act, and that sets out the rules for incorporating and what you have to do, how many directors you have to have, how often you have to have board meetings, the idea that you have to have at least 3 directors, that you have to have a secretary and a treasurer as officers, and the secretary is the official keeper of the records, treasurer, of course, is official keeper of the books, and so that's what that is. Okay, and that's what guides our discussion, and as we go along with what is required to do business in the corporate form, and it's strict compliance, right? Now, let me just make sure we understand while we're kind of talking about that. If you are incorporated in a state, for instance, you want to incorporate in Illinois, once you have issued the charter and had your meetings, you're known as you're a domestic corporation for Illinois. Okay, you're a domestic corporation for Illinois. Now, if you want to do business. Once you have incorporated in Illinois in another state, guess what? You have to register with the Secretary of State's or whatever official it is in that state and fill out the appropriate paperwork in that state to register as what we call a foreign corporation. And what you're asking to do is say, oh, I'm incorporated in Illinois, but I want to do business in Missouri too. I need to register as a foreign corporation, and I'll fill out the paperwork and pay the fees, right? Everybody understand that? So if you are incorporated in one state and want to do business in another state, then you must register, and then you will be a foreign corporation in that state. And so you can have one domestic, be a domestic corporation in one state, but then you can be authorized to do business as a foreign corporation in the other 49. But if you want to do a multi-state business in the corporate form, do you have to register in each state? Yes. Yes. Or you may not be treated like a corporation. The act requires strict compliance. Okay, it's not that big of a deal. It's kind of a pain. But yeah, you do have to do that. Now, you may ask yourself, well, foreign corporation, then what if you're actually incorporated under the laws of a foreign nation and you want to come and do business in a state? Can you register? Yes, and that's called an alien corporation, that you register as an alien corporation. That's a corporation formed under the laws of a different country. Okay, but by registering, what you're essentially doing is you're agreeing to abide by the laws of that state, right? And also to recognize the jurisdiction of the courts of that state over your corporation should someone want to sue you. Okay, yeah. All right, so everybody understand that? Okay, any other questions? All right, now let's get to Buffalo Creek here. And real quick, I want to kind of stand back. And I think by now, hopefully everybody's read the first part of Buffalo Creek and responded to the first set of questions that can be found. And just the facts of Buffalo Creek are fairly straightforward. It's a mass tort. Essentially what you had here was a impoundment of wastewater from the coal mining operations. The impoundment of wastewater, essentially a dam, was made up of waste material they had gathered from the mine. It started out fairly small, but over the years has had it expanded. One of the interesting problems, one of the problems that Buffalo Creek was having, and this is it kind of goes back into the coal mining history, was that before you can ship coal in interstate commerce, you must clean it. It must be washed. Okay, why? Everybody could think about it. Well, why before you can put coal into a rail car and ship it in interstate commerce, sell it, it's got to be washed. Why? What are you doing? You're taking the dust off of it. You're washing the coal dust off of it. What's the problem with coal dust? Kaboom, baby, kaboom! Remember the main. Coal dust is a very, very, very explosive material. If you mix coal dust in the air and blow it up, put a spark in it, you'll get one heck of a big explosion. It was a big problem for navies that were using coal to fire their boilers. There's all sorts of stories about different ships that really ended up being blown up, not by enemy action, but because their coal bunkers blew up. And so it's a main problem. If you ship coal in interstate commerce, without washing it. Of course, the coal dust, when the train would go underneath through tunnels and underneath overpasses, that coal dust could do what? It could accumulate, and all you take is a little spark, such as from when the wheels crush a rock under the rails, and you got a what? Kabooey. Big explosion, and that was a problem. And eventually, then federal regulations and state regulators made coal producers begin to wash the coal before they could ship it. Now, that creates a second problem. What's the next problem that creates? That you are doing what? You are contaminating a whole bunch of water. Now, and originally, the producers would simply dump the wastewater after they had washed the coal back into the river, back into the stream. And interestingly, of course, what happened to the quality of that water when you put that coal dust, which contains all sorts of heavy metals and nasty things in it? What happens to the aquatic life downstream and the viability of the stream water? It disappears, right? It becomes poisonous. Fish die. And interestingly, there wasn't a big outcry because the water was the contaminated water that the coal mines were producing was killing people. All right, that wasn't the point. The point was that, and this is very interesting, this has happened in many states when mining interests would begin to contaminate waterways, was that the sport fishing industry went bananas. Yeah. That, of course, in all of these hollows and creeks in the mountains, that for years predating that, there were some of the best trout fisheries, salmon fisheries in North America and the entire world. Everybody understand that? And back when we were beginning to really develop mining, those interests were already established, and it wasn't poor people that were fishing. It was what? The rich folks. There were all sorts of resorts which would cater to rich folks, people of means, that would want to come up to the mountains and go fly fishing or go fishing for salmon. Right? Everybody with me and understand that? Yeah, big tourist business. And when coal mining then began to take away that sport fishing industry, of course, the lodge owners and the rich folk got all up in arms. And they immediately then, and it wasn't because they were worried about the people downstream, believe me, being poisoned. That wasn't the issue. The issue was what? They were killing their sport fish. And immediately, those moneyed people, those influential people, then got state regulators, and it was state regulators originally, then to begin to require them to somehow do something with that wastewater, not just dump it directly into the streams. And in fact, if you look at environmental regulation from a historical standpoint, especially with regard to clean water, it was done at a state level early on in response to pollution caused by the mining industry, and it was a direct result of lobbying by the sport fishing industry, which is kind of, I think, interesting, and it still kind of works that way, frankly. And so, yeah, everybody, and so they had to do something else, and what they came up with is they created these impoundments, and they are still used today, and it's real. They use gravity, and it's a very simple way of taking heavy metals and the worst of the contaminants out of the wastewater when they wash the coal. You see this, I've actually seen this, I don't know what those of you are familiar with Horseshoe Lake State Park. Granite City Steel has a containment pond there. And what they've done is they've used some of the stuff from the production of coke, slag they call it, and they've made a big dam. They pump their wastewater into this dam, this containment. It does look like a horseshoe. And they pump it up higher than the lake water. And what happens, they use gravity then to force that contaminated water through this mound of slag, which is 40 foot wide and 25 or 30 foot tall. And when the water percolates through that wall of slag, it loses a lot of the contaminants and actually comes out, and the EPA tests it, and actually comes out the other side um, able to pass EPA standards, even after being contaminated by the waste from the steel mill. And the same thing happens at Buffalo Creek and other coal mining sites that are using this type of way to screen the water. They take the offal, the scrap left from mining operations, they build an impoundment, they fill the impoundment, the water percolates down through the impoundment and enters the stream directly, percolates through and enters the stream in a quality that is sufficient to meet standards. Okay, fairly simple, fairly straightforward, works. However, one night there's or one, I guess, several over a period of time. Nature has a surprise in store, and we have excess rain for a period of time, and eventually the impoundment fills with rainwater runoff. The impoundment itself begins to lose integrity, and what happens? Away it goes. And you have essentially this wave of water with the debris it collects along the way. It's a lahar, I think, essentially, and it strikes the town of Buffalo Creek. And the story of Buffalo Creek, the novella, is about the efforts of an attorney then, since this is a mass tort, to obtain compensation for his clients, the victims of the incident. Okay. All right. So that's basically the setup for Buffalo Creek, and this then the novella then goes on and begins then to illustrate for you. It's actually a case study of some of the difficulties and problems encountered along the way, and the positions that were taken by Buffalo Creek and its parent company in defending the litigation. And let's set that up real quick too. Buffalo Creek, I believe 3 or 4 years prior to the incident, maybe only 2 years, 3 or 4 years, 2 years, something like that, I forget now. Prior to that time, Buffalo Creek had been an independent corporation, right? It had been organized and operating, if I'm not mistaken, under the laws of West Virginia, right? Everybody understand that? Yeah, it was originally organized as a West Virginia corporation, okay? And its principal place of business was where? West Virginia, at the site. And they were acquired at some point in time prior to the incident at hand. They were acquired by Pittston Mining prior to that incident. Now, Pittston acquired all of these shares, apparently, all of these shares of Buffalo Creek. And so Pittston was the sole shareholder of the shares in Buffalo Creek. Okay, everybody with me to understand that? Yeah. Now, Pittston was organized, if I'm not mistaken, under the laws of New York, if I'm not mistaken. So it was a domestic corporation, and I believe its principal place of business was also in New York. Okay. Um, Now, the attorney representing the victims very early on recognized he had a problem. And it's a problem that I, as a litigator, have encountered directly before. And here's the problem. He could sue Buffalo Creek in West Virginia State Court, alleging Buffalo Creek, the corporation and its executives, were negligent. That is, that they owed a duty to operate their mine in a safe and suitable manner, that they failed to do that, that failure, that breach of that duty to operate the mine in a safe and suitable manner was a direct and proximate result of damages to his client, and therefore his clients are entitled to compensation. Now, what's the problem? What's the problem that he recognized? Well, one of the problems he recognized almost immediately was that in a state like West Virginia, that the coal mining industry as a whole wields a huge amount of political influence and power, and that any judge sitting on a state court bench would have, at some point in time prior to becoming a judge, done what? Been an attorney for the coal mining industry. Everybody understand that? I mean, just make sure that and it works like that, is that the coal mining industry is going to make sure that their interests are protected and represented by state court judges that have in the past represented the coal industry, right? Everybody understand that? Yeah, make sure you do. And he recognized, and the attorney for the victims recognized immediately, if he files suit in state court, then he's going to end up with a judge that is going to bend over backwards to rule for the coal companies. And he knew that the cases had enough ins and outs legally, and we'll talk about those next week, that he could find himself and his clients, they could find themselves dismissed out of suit, dismissed out of court, without ever having an opportunity to have a jury hear their case. And he was also concerned then that if he would appeal that trial court judge's ruling dismissing him, then he'd be facing an appellate court also with what? Stacked with judges that had been formerly represented the coal mining industry. And so he was deathly afraid of litigating in state court because of the perceived prejudice, he thought, and I think it's probably appropriate. And I have litigated cases throughout the southeastern United States, and I can never forget going. I represented a railroad worker in an FELA case. I was in Covington, Kentucky, and I go for a pretrial with my client to discuss how we're going to try the case and how things are going to go. My defendant railroad is the L&N Louisville and Nashville Railroad. The judge walks out into the courtroom. He doesn't have a robe on, but by God, he's got a tie on, and his stick pin in his tie is an L&N Railroad stick pin. Was he sending me a message? Yeah, you better believe he was. Yeah, yeah, and we ended up trying the case. And believe it or not, I did pretty good. I got to a jury, and I got a good result of the jury. But before I had gotten home, the judge had taken it away from me, taken the jury verdict away, and ordered a new trial. So those things do work that way. Now, so he knew that, and one of the things we understand is that the place that you choose to fight the battle as lawyers, that can have a direct outcome. And so he decided he needed to get not in state court, but into federal court, which he thought his perception would give him a much better chance of a successful outcome for his clients. Okay? Now, he had a problem with that. And we've kind of set this up. If for him to be able to file suit in federal court, he could not name Pittston directly. And we're getting into a little bit of the legal weeds here. But the two things, the things that you do have to understand, we have overlapping court systems. We have the state system, and he could have filed in the state system. But we also have an overlapping federal court system. But the federal courts, while state courts are what we call courts of general jurisdiction, they hear all sorts of things, as long as the controversy arises within their jurisdictional territory boundaries. Controversy arises within the state of Illinois, then generally the state's courts of Illinois are going to be empowered to hear that case. Okay? However, federal courts are what we call courts of limited subject matter jurisdiction. They can only hear certain kinds of cases. The first kind of case that a federal court can hear, and generally this is federal, what we call federal question subject matter jurisdiction, federal question. If the question or controversy surrounds some sort of federal legislation, the United States Constitution, some act of Congress passed by them and signed by the president, some federal regulation of some administrative agency. As long as there's a question of federal law involved, the courts can hear those cases. Okay, but we don't have that here with Buffalo Creek. That's not what we have. What we have here is the court, and what the attorney's trying to do is get what we call a tort case heard in federal court. Now, there is this thing called diversity jurisdiction. You need to understand that. Hint, hint, buzzword alert. Diversity jurisdiction. And what the diversity? Root word is diverse. And what this type of case that is allowed to be heard by the federal courts, it's if the claim being brought is based upon state law, generally it's contract law or tort law, then a federal court can hear that state law-based claim, contract law or tort law, if and only if there is complete diversity of citizenship between the parties. Let me say that again. That federal courts can hear state law-based civil claims, generally based on contract law and tort law, if and only if there is complete diversity of citizenship between the parties. That is, no plaintiff and no defendant share a common state of residence. If there is complete diversity of citizenship, If there is complete diversity of citizenship, then a federal court can hear a state law-based claim on contract or tort. However, if a plaintiff and defendant are from the same state, share a common state of residence, then there is no diversity jurisdiction, and therefore it's got to go to state court. Can't file it in federal court. All right. Now this presents Stern with a dilemma. Buffalo Creek is a West Virginia corporation. Domestic West Virginia corporations' principal place of business is in West Virginia. Where is his clients from? West Virginia. So if he sues Buffalo Creek, he has to do it in state court. He cannot do it in federal court. Okay? Everybody agree with that? But he don't want to do that because he knows he's going to get tossed out if he does it that way. So instead, he does not sue Buffalo Creek directly. Who's he sue? Pittston. All right, so now let's look at that. Pittston's a corporation that's organized according to what? The laws of New York. Its principal place of business is where? New York. Okay. All right. Where is his clients from? Where's Stern's clients from? West Virginia. All the plaintiffs are from West Virginia. If he sues only Pittston, then the defendant is from New York. He therefore has what? Complete diversity of citizenship. That is authorized, that type of suit. It's a tort claim, mass tort claim. That type of mass tort claim is authorized then under federal law. He can file suit in federal court. But what's the problem? There's a problem, and he took a big gamble with this. He took a big gamble. What's the problem? If you're Pittston and you are being sued for the actions of Buffalo Creek, what is your defense going to be? What's your defense going to be? Is what? That I committed no overt negligence, that I am simply the sole shareholder of Buffalo Creek, that all of the actions were the folks of Buffalo Creek, and that since Buffalo Creek is a wholly owned subsidiary of Pittston, there is a corporate veil then between Pittston and Buffalo Creek. And Stern's clients cannot hold Pittston directly liable, right? Buffalo Creek may be liable, that their executives and that corporation's actions may have been negligent, but there's that corporate veil. And what Stern must do then to be able to collect and overcome that argument is that he must document that Pittston did not treat Buffalo Creek as a wholly owned subsidiary, but they actually treated it like a division of Pittston. In other words, they were treating it like it was its own little what? Sole proprietorship. And so what did Stern do? When Pittston says you can't hold me responsible for Buffalo Creek's actions because it's a wholly owned subsidiary and there's a corporate veil between us, what did Stern do? Stern said what? Well, okay, let's call your bluff on that one. I want the documentation for your board of directors meetings for Buffalo Creek. In other words, did you actually operate Buffalo Creek? Did Buffalo Creek have a board of directors? They probably did a name. Did they have meetings? They said they did. Did they have documentation of those meetings? They said they did, but it ended up they didn't really. Right? Everybody with me and understand that? Yeah. Yeah. And so if Stern could pierce the corporate veil. That is, show that Pittston was operating Buffalo Creek not as a wholly owned subsidiary with its own independent board of directors, which had meetings and made decisions on what was going to be done with Buffalo Creek, how it was going to be operated, on and on and on. Did those exist? No. And what we found, what Stern was able to uncover then is that Pittston was, the executives, probably the board of directors of Pittston, was making decisions on their own about how Pittston was going to be operated. Right? Yeah. And clearly, they were treating it then as what we call a division of Pittston, not a wholly owned subsidiary. Okay, and so he did that, obviously, then to avoid the influence of state courts. And by us, we down in Madison and Sinclair, Illinois, we have just the opposite. We believe we have a judiciary that appropriately reflects consumer interests and the interests of the citizens of those counties rather than the corporations and special interests. And down by us, if you're a plaintiff's attorney, you want to be in state court because you want those judges to hear your cases, whereas if you represent defendants, generally they'll be insurance companies and corporations. What do? You do everything in your possible to get out of state court and into federal court, where you believe the judges will have a more sympathetic ear to whatever it is you're trying to peddle in defense of your client. Okay, I think that sets Buffalo Creek up pretty well for you, going into the next sections. And so I think I'm going to leave it at that. I am going to try to record some more videos and post them. I'm probably going to do it here. If this one, I will get this one processed and post it up. One of the problems I think we may be having too is these things are massaged a couple, 3 times before you eventually get to see them. They're recorded at the Zoom website. I've got to download those from Zoom onto a stick. Then I have to upload those from my stick onto YouTube or one, at both those steps, the recordings are processed and massaged, and perhaps that's causing part of the problems with the audio. But if this works, and this one is a better quality video and audio, then you'll be hearing from me from Rancho Schooley here in the Draper Valley instead of the public library. Okay, questions? Anybody got any issues they are going to want to raise? I am grading. I know I have a little bit of catching up to do, Lacey, and I'm gonna grade your new exam soon here. So, anybody got any questions? Any problems? How's the skiing? It's wonderful. It's been great. That's what I'm kind of like giggling. It's this morning we had storm over the weekend, and some areas maybe got 35 inches over the weekend. I was up Sunday and yesterday and today, all 3 days. This was my 8th day out of a possible 12. I went up today. It was very cold, but God, it was gorgeous. It was a clear bluebird sky, and there was a bunch of new snow. It was 5 degrees in the parking lot and -5 at the top of the ski lift, but it was just wonderful. And I'm hoping, and I'll leave you with this. I am hoping I'm going to dig my GoPro out, and I am hoping I'm going to be able to capture some footage. And since I have just opened a YouTube channel to post some of these videos on, I may try to upload some GoPro, and I'll keep you guys noticed. You guys can enjoy the scenery along with me. Okay. All right. Yeah, I always, yeah, well, the risk taking is part of the whole deal, right? Yeah. Okay. Anybody else got any questions, comments, observations? Yeah, hang in there, folks. We're almost done, right? Woo! All right. Yeah, so I'll post videos, get the grades going, and if nothing else, we'll see you again next Tuesday. Okay. All right. Thank you, guys. Need anything, about anything, reach out. You guys know how to do that. Okay.